Good morning, Mr. Burns. Can you please state and spell for us your full name?
Gene, G-E-N-E, Mark, M-A-R-K, Burns, B-U-R-N-S.
Mr. Burns, at one point in time you worked for the state of Arizona, correct?
I did.
From when until when?
From September of 1997 to March of 2015.
Beginning in 1997, which department did you work for?
Child Protective Services.
Did you continue working for Child Protective Services until March 2015?
I did.
In what capacity were you first employed back in 1997 by Department of Children? I'm sorry, is it Child Protective Services you said?
Yes, a program manager.
What does a program manager do?
Manage the field level. At that time it was for Child Protective Services in Maricopa County.
Did your job duties change at all from 1997 to March 2015?
Yes, Maricopa County was split, so I managed the western half of Maricopa County, Yuma County, and La Paz County.
When did that split happen?
I don't recall. I think somewhere around 2009 to 2010.
And just so I'm with you, you then became the program manager for the Western region?
Southwestern region.
Southwestern region. All right, what does a program manager do? In 2009 and forward for the Southwest region, what did you do? What were your primary job duties?
It managed the business operations of the Southwest region and for the Central region. I oversaw the deputy program manager who was responsible for the assistant program managers who were responsible for the supervisors.
How many deputy program managers were under your supervision?
One. I also managed the court liaison, the resource manager, I can't remember who all I managed. I managed around 7 people.
Okay, so we have the deputy program manager, and then we had an assistant program manager, or assistant, what was that person, assistant deputy manager? What did we call them?
The deputy program manager was actually over the field assistant program managers.
Okay, and how many assistant program managers were there?
I believe 7.
And then the assistant program managers, they had control over supervisors in the field, is that right?
Yes.
How many supervisors in the field were there in the Southwest region during the time that you were the program manager?
I can't recollect for sure. Usually each section had 6 to 7 supervisors.
And when you say each section, are you referring to sections within the Southwest region?
Yes, so there were offices listed as Avondale, and so there was in-home, adoptions, the young adult program, that type of thing.
Okay. So when we're talking about the sections, I'd like to focus just for a moment on sections that would normally be responding to referrals that come into the agency. What would we call those sections?
They had names. Mm-hmm. So a section such as Thunderbird would have 3 to 4 investigative units and then maybe 3 ongoing units, and they took certain zip codes.
Okay, so Thunderbird, I presume that refers to like a region within the larger Southwestern region.
Yes.
Okay, and then you'd mentioned earlier like Avondale. Would that also be a section?
Yes.
Okay, and that would have a similar composition where we have 3 to 4 investigative units, and then we would have 3 or so ongoing services units.
Yes, Avondale was a little different in the fact that it was co-located with a police unit.
Okay. And then when we talk about 3 to 4 investigative units, what do you mean when we're talking about an investigative unit? What is that?
Investigative unit.
Yeah.
They take reports from the hotline that are prioritized by priority, which is assigned by the hotline.
Okay. And then what do they do with those reports?
They go out on those reports and meet the response time assigned by the hotline. So they would look at any priors that may have, and they may staff that with their supervisor prior to going out.
Okay, just for my own understanding, just make sure I'm clear. And if I'm wrong on any of this, please interrupt me, stop me, and correct me so I don't go down a rabbit trail. But so far, what I think I'm understanding is a call will come into the hotline, and somebody will take that call, they'll write up whatever the referral or the complaint is. That will then get assigned to a person, an investigator, who will then go out into the field and start interviewing witnesses or investigating the allegations of the referral. Do I have it right so far?
The hotline will assess whether it meets the criteria of a report. If it meets the criteria of a report, it will be sent to a particular unit who has that assigned zip code. The supervisor then will decide who gets that, what investigator gets that report.
Okay, so once it's been decided that yes, this hotline call meets the criteria for a referral, then the referral will get generated and sent out to a unit, an investigation unit.
Object, just for clarification, you use the term referral. He uses the term report, just so we're talking about the same thing.
Okay, do you guys use referrals when you get a...
The term is report. A call goes in. The term is report.
Okay. I guess every government agency does it a little different. Out in California, they call them hotline referrals. But reports then, so if the report meets the criteria, it'll get assigned to a investigator somewhere, whether that's by a supervisor or some other staffing unit. And then that investigator is supposed to go out in the field and actually interview witnesses and follow up on the allegations of the report. Is that right?
Yes.
Okay. Now, there's some circumstances where a report may get generated and the investigator goes out and detains the child. That happens, right?
Could you clarify that?
Well, how do children come within the custody of the agency that you used to work for?
Okay. In Arizona, an investigator has the right to remove a child with it for 72 hours if they feel the child is at risk of imminent harm. A child and also a voluntary foster care agreement can be signed by a family member placing that child into care for 72 hours. Or another way kids come into care is family members can go to the self-help center at court and a petition is filed and those kids are placed into the custody of the department.
Okay, let's focus just for a moment on the situation where one of your investigators gets assigned a report, they go out in the field to investigate the report. Are you telling me that that investigator on their own can remove the child from the custody of its parents if the investigator feels that the child is in danger of some sort?
Based on their interviews, based on what they're seeing in the home, usually they will call their supervisor. They will get they'll staff over the phone what they're seeing, and if that supervisor agrees, they can remove.
Is there some sort of criteria or something that has to be met before we can remove a child from their home without getting a court order?
The department has a risk assessment tool they use.
What's that called?
been a long time, so it's been 15 months. I think they've changed it. I think it's a child risk safety assessment.
Is that a computerized tool?
No.
Okay, describe it for me. How does this risk assessment work?
People are trained on it. It assesses various domains. 17 risk safety factors. I've been away from it for 15 months, so I couldn't give you the risk factors.
Sure. When did the department first begin using this risk assessment tool?
I can't tell you that. I don't recollect.
But it was sometime between 1997, when you began as a program manager, and March 2015?
Yes, there's been various tools used, and it's been modified several times.
And when you call this a tool, maybe I'm misinterpreting, correct me if I'm wrong, but normally when I'm talking about a tool, since it's not a computer program or a computerized tool, there must be some sort of forms or something that you use to administer this tool.
There is a document.
So there is a document. And just describe for me, what is that document composed of? What does it look like?
It has 17 risk factors, domains.
And these risk factors on the document, are there questions maybe that the social worker has to answer?
It goes through.
Wait till he's done before you start to answer.
Yeah, I should have given you that little instruction at the beginning. I presume you haven't been deposed before, is that correct?
I'm sorry, what?
You have not been deposed before?
Not in the state of Arizona.
Okay. Basically, one of the rules is you can see that she's trying to type down everything that we say. And one thing that's very important for her to do that is that we not talk at the same time. Otherwise, it gets very difficult. But, that's not your fault. That's my fault for not letting you know. So anyway, this risk assessment tool, am I correct that it's these 17 domains that you talked about? There's a series of questions associated with those 17 domains?
17 safety factors.
Okay, there's a risk of questions associated with those 17 safety factors.
There's 17 risk safety factors that you have to assess whether they're there. Like I said, I don't particularly remember them. It's been 15 months, and I didn't use it daily because I was removed from the field.
Did you ever participate in the administration of any training for the social workers or the investigators that were under your management at your office?
I did.
Okay. Did you ever participate in administering any training specifically relative to the use of these risk assessment tools?
Did I train the document? Is that what you're asking?
Did you participate in training on the document? Yeah.
I participated in the training. I did not train the document.
What does that mean?
I participated in the training of the document, but I did not train the document to staff.
When you say you participated in the training on the risk assessment tool, what do you mean?
The department has specialists that train on the risk assessment tool.
Okay. And how did you participate in that effort?
I sat in the training.
So you actually sat through a training?
Mm-hmm.
Yes?
Is that yes?
Yes.
More than one?
Yes.
Okay.
I sat when they had various modifications of the document.
Okay. Roughly, just give me an estimate. How many of those trainings did you sit through? Between 5 and 10 or something like that?
I don't know, probably more than 5.
So you should have a general understanding about how the tool is used in the field.
I do.
Okay, can you go ahead and explain that to me?
You're going to have an assessment of if the kid is at risk. You're going to look at, when you interview the child, look at the home, look for various safety risks and hazards. You're going to look for whether or not there is abuse in the home, whether or not there's domestic violence. whether or not there's substance abuse. You're going to look at a wide array of issues.
Well, when you say wide array, that's the 17 risk factors
Safety
or
factors.
safety factors?
Yes, but you're going to look at past. Was there a history of abuse in the past? Was there any other allegations in the family?
And am I correct that before the decision to seize or detain a child is made, the worker out in the field must do this risk assessment?
Not necessarily. If an investigator feels that the child, if they would leave, is at risk, they can pull the child.
When you say at risk, explain that to me. What do you mean?
So if that investigator feels that if they left the home, the child would be in danger, they should pull the child.
How long does it take in Maricopa County if the social worker feels like they can't leave the home? How long does it take them to get a warrant to remove the child?
Form and foundation, and form and foundation at this point. If you know the answer to that,
I'm not familiar with using the term warrant, because we don't do warrants in Arizona.
Let me do it a little bit differently. You were the program manager for the Southwest region for about 18 years, is that right?
17 and a half.
17 and a half years. In that entire 17 and a half years, did you ever see a circumstance where one of your field workers obtained a court order permitting them to detain a child from the custody of its parents?
Okay, let me just explain the practice.
Sure.
Okay, but basically, you do not need a warrant for DCS, if you read the statute, to remove a child.
And when you say if you read the statute, you mean the state statute?
Yes.
Okay, what are the circumstances under which one of your workers could remove a child without a warrant?
I'm sorry, I thought I explained that. If a investigator goes to the home and they believe the child is at imminent harm, and should they leave, that child would be at risk, they would call their supervisor, staff it. They can.
Supervisor staff?
If they would staff the situation with their supervisor, then they could issue a removal notice.
Okay, the worker couldn't do that on their own. They would have to get agreement from their supervisor?
If the supervisor is not there, they may call another supervisor or the acting supervisor.
Okay, but there would definitely have to be some supervisor involvement in the decision to seize that child.
assumes facts, objection.
I cannot say that for sure.
According to policy, the policy that was in place when you were in charge, what was the policy?
That varied sometimes depending on the experience of the worker.
Was that written somewhere in policy that depending on the experience of the worker, that worker can go ahead and make the decision on their own?
I can't tell you that. I don't know.
Okay, so as the program manager, that's not something you would
If you had an experienced staff, I don't know. I don't know if that was in writing.
Did you participate at all in drafting or promulgating the written policies that govern the work that your subordinates did?
I did if it was a district operating procedure.
The procedure to detain a child from the custody of its parents, would that have been a written procedure or one that just sort of was done in practice?
That would have been in the state manual.
State manual, okay. And your recollection of the state manual is that under the statute, depending on the experience of the field worker, they may or may not need to consult with their supervisor.
Object to form misstates testimony.
I don't know if it's in the manual. I can't remember.
Okay, so, but you do recall that as a matter of practice, it was permissible under your command for experienced field workers to seize children sometimes without consulting a supervisor.
If you were a social worker or something like that, or you're an acting supervisor, Yes, but usually the norm was you called your supervisor.
And get supervisor approval. Yes.
Yes.
You have to answer audibly because
That
she's
was
got
the
it.
norm, the supervisory approval.
And when we're talking about risk, you described this for me a little bit earlier, that if the child is in, I think you said, imminent risk of harm. What are we talking about there, imminent risk of harm? What does that mean in layman's terms?
It means if they left, would the child be at risk of being hurt or severely neglected?
Is that it?
Pretty much.
When you say at risk of being hurt, is there some degree of injury that we're talking about there, or could a scraped knee be sufficient?
I didn't catch the last part.
Well, you said if the child's at risk of being hurt, and I'm wondering, what does that mean?
If you look at the reasons for the report, if a child is going to be at risk of being abused again, depending on if it's a neglect case, depending on the conditions of the home, is it a hazard? It's all going to be individual.
Do you have any understanding, or let me ask it this way, did you gain any understanding while you were the program manager for the Southwest region? Did you gain any understanding that the work that you guys were doing out there was governed by Ninth Circuit law? Anybody ever tell you that?
We were governed by the federal review, yes, and then our cases were reviewed by the feds. Yes, I'm aware of that.
Well, my question is really more specific than that. You understand that in the United States, we basically have a dual legal system. One is federal law, the other state law. You understand that, right?
Is that a yes or?
Yes, let me tell you, I'm not the policy person at DCS. So the policy is set at what was central office, so I follow the manual. Does that make?
That they send you.
Yes.
Okay. I understand that. I'm not there yet. We're going to get there probably a little later in the day. What I'm looking for now is just to sort of get a general idea of what your level of understanding is with respect to just the general law that governed the work that you and your subordinate workers were doing, back between 1997 and 2015. So let me ask the question again. You yourself do understand that we have a system where federal law and state law both apply to the work that you're doing for CPS, right?
I do understand that federal law was incorporated into the mandates that we've addressed.
Do you have any understanding as to whether or not the state of Arizona is in the Ninth Circuit?
Yes.
You do know that?
Yes, because I know it's in the federal review.
Okay. And being in the Ninth Circuit, you also understand that the work that CPS is doing here in Arizona is governed by Ninth Circuit law. You understand that?
And that would be under the jurisdiction of juvenile court.
Well, hold on. That doesn't really answer my question. My question is, you understand. I'm not asking about jurisdictions.
I'm not an expert, but it does make logical sense to me.
Okay. When you were program manager, did you ever participate in any meetings or conferences, management groups, anything like that, where the application of Ninth Circuit law was discussed?
No.
No. Okay. But
Not that I recall. Let me put it that way.
But irrespective of that, it's your understanding that the work that your social workers and investigators, that your CPS agents were doing during your tenure in management, that it was governed exclusively by the state statutes.
Object to form, misstates testimony.
Am I right about that?
I'm sorry, what?
I'm just objecting. You can go ahead and answer.
Yeah. Yes, and the manual.
I'm going to show you what we will mark as exhibit number 63.
I'm familiar with it.
Before we get into it, I'll ask you, and you may not have heard this before, you may not be familiar, just let me know. Have you ever heard that in order to remove a child from the custody of its parents without a warrant, the CPS agent must have reasonable and articulable evidence to suggest that the child is in immediate danger of suffering severe bodily injury or death in the time it would take to get a warrant? Have you ever heard that statement or something like it?
No.
So that's not a rule that Arizona follows?
Objective form does not, first of all, he has no foundations of what Arizona follows. He can say what he knows.
Well, he can
You can't
answer that.
speak.
Are you instructing him?
Well, I'm telling you, I'm objecting to the form of the questions,
Okay,
assuming
that's-
facts, and
that's-
he has no foundation for this, and you've set no foundation.
That's the objection, then you can't coach him. The objection is that you object as to the form of the question. Thank you, I'll ask the question again. Actually, if I can just have you reread the question, I would appreciate it.
The last question was, so that's not a rule that Arizona follows?
Foundation.
I have not. It's not anywhere like that in the manual, no.
Okay, and just to address the foundational issue, we'll go ahead and do it again. I thought we did, but we can again. It's okay.
Before you do that, just so your foundation, I don't know that you can establish foundation. He can tell you what he knows. He can tell you what he thinks, but he can't tell you what the state of Arizona did or didn't do.
Well-
he can tell you what he knows or thinks they.
We're not going to get into that here. A judge is going to decide that question. I think you're dead wrong on it, and a judge will let us know when the time comes. That being said, if you want to confer with me in private, we can do that, but we're not going to do it in front of the witness. I'm entitled to his testimony from his mind, not from yours. So
Nor
let-
from, you're not entitled to his testimony from your mind either, so go ahead and try to
He'll tell
straighten
me.
it out.
He'll tell me if I'm wrong, and if you keep doing this, we'll just suspend it and go in front of the judge, and he'll have to come back here another day. Is that what we want to do here?
Just set your question, and I'll make my objections. If you make
Let's
it
just
a
keep
proper
them to a-
question, we'll make it proper objections.
Let's just keep proper objections, and this will flow right along. So, addressing the foundational issue, you were a program manager for the state of Arizona, CPS, for 17 and a half years, right?
Yes.
In the context of that job that you did you ever get any training of any kind from the state of Arizona?
Yes. Did I receive training from the state of Arizona? Yes.
Okay. And as part of that training, you were trained regarding the criteria that your subordinates had to meet in order to remove children from their parents without first getting a warrant, correct? That is a yes or no question.
No, it was never worded that way.
So you were never trained about the criteria that had to be met before your subordinate social workers or investigators could remove a child from its parents without first getting a warrant. You were never trained on that.
Argumentative foundation.
We were trained in the document that you just gave me.
Okay.
We were not trained that you had to get a warrant,
Were you
which
trained?
I think I talked to you before.
Were you trained regarding any circumstance at all under which you might need to actually get a warrant before you remove a child?
We were trained on when you go out with the police and what reports are co-investigated with the police.
I'm not sure that's actually responsive to my question. Can I get my question reread, please?
Were you trained regarding any circumstance at all under which you might need to actually get a warrant before you remove a child?
I think I answered that, but not that I recollect that when we get a warrant.
Okay. And I'm correct, aren't I, that as a matter of practice, at least in the Southwest region, according to your training and your understanding that the state of Arizona gave you, there were no circumstances under which you would be removing a child where you would actually need to go get a warrant.
If we were in with the police would make that decision.
To get a warrant or to remove the child?
if we were going with the police, they decided to remove a child, they might get a warrant. But no, not CPS. I don't recall us actually doing a warrant unless a child was out of state.
What do you mean unless a child was out of state?
Unless we needed to pull a child from out of state, and I may be misspeaking, but if a child was run away and we needed to get that child.
Okay. Have you ever been taught by the state of Arizona or trained by the state of Arizona that if there are lesser intrusive alternative means available to protect the child, then you cannot remove the child without first getting a warrant? Ever been taught anything like that?
The standard, and it says that right here, we always try to go least restrictive. So services are always offered. If services can't be, if services are turned down, you would go voluntary foster care.
What does that mean, voluntary foster care?
In the state of Arizona, if you don't believe services would address the issue, then a voluntary foster care agreement, a family could place their child in voluntary foster care for 72 hours. That gives the ability, I'm sorry, it's 90 days, gives the ability for everything to calm down and to assess what's going on in the home, and then the child would return within 90 days.
When you say voluntary foster care agreement, do we also call that a safety plan?
It's different. There's a safety plan with the relative. There could be a safety plan made in the home.
Okay. So when we're talking about a safety plan with a relative, that would be like a grandparent, an aunt, an uncle, something like that? Mm-hmm. Yes?
Yes.
Yeah. And it would be a situation where the parent or parents would voluntarily agree for a short period of time to put the child or children with that relative.
Yes.
And the difference between that and a voluntary foster care placement would be it's the same sort of setup with the voluntary foster care placement, except that the child would be going to a non-related foster care placement instead of a relative, right?
Yes, it did change. I can't remember when. There's been off and on that you can put a voluntary care agreement with a relative, and it's changed depending on the administration.
Okay. Now, focusing just for a moment on this concept of a voluntary safety plan, that's where we're going to place with a relative or close family member. What's meant by the term voluntary?
A voluntary agreement is when they go to the family and they say they have there's some concerns, and one of the things that you can do is to address those concerns is to say you can put your children with family, and that will stop a petition from being written.
Okay, it'll stop a petition from being written.
Or a removal.
In order to truly be voluntary, though, that agreement, it can't be coerced in any way, can it?
You're just giving a family a choice. You're giving them, this is option A, and this is option B.
Well, what would option B be? If the option A is the safety plan, what's option B?
That if you do not do that, we would go and do a removal.
So for example, I'm an investigator. I show up that night to investigate a report. I look around, maybe have issues with what I see there. I go to the parent and I say, look, you got option A or option B. Either I'm going to seize your child from you tonight, or you can do a voluntary safety plan. Is that sort of how it works out?
Well, you're being transparent with the family. So you're telling them they have choices. And so it's just like with employment. You can go unemployed or you can accept a job. Is that coercion or is that a choice?
Focus on the question for a moment. I understand you may not want to answer it directly, but let's focus on the question for a moment.
I think we're interpreting it totally different. I say it's a choice. You say it's coercion.
Okay, let's focus on the question. My choice is, correct me if I'm wrong, you're the investigative worker, You're with me that night and you say, look, you've got a choice. Am I right so far?
I'm an investigative worker. I would tell you what my concerns that I'm seeing in the household are, and I would tell you why I have concerns, and then I would be transparent with you, and then I would tell you that I'm looking at a removal or there's an option of a safety plan.
Okay, and you would essentially tell me if I don't sign the safety plan, you're going to remove my child from me right there and then.
I would say you have a choice.
And the choice is?
That you have an option of a safety plan that is least invasive. Or if you do not choose to do that, there would be a removal.
Okay, right then and there, without a court order or anything else, you just remove the child.
In accordance to the policies of Arizona.
Okay. And it's your understanding that the investigator has the power to do that under both state and federal law, has the power to do that if the child is at risk of some kind of harm.
As determined by their investigator.
The social services, the CPS investigator on the scene that night.
Yeah, so when they've consulted with their supervisor, yeah.
When we're talking about that risk of harm, is there some temporal element, some time element involved there?
No, you're going to go through the tool. You're thinking about that tool. You're thinking about what's going to happen. It's going to be individualized, what's going on in that home. You're going to make an assessment.
Well, when I talk about timing, I'm wondering, I mean, if a child's going to suffer, let's use a school-age little girl that gets raped by her stepfather every Tuesday at 6 p.m. Let's use that as our example. You get the report, your social worker or your investigator goes out to the girl's school at 9 o'clock in the morning on Tuesday, investigates and says, you know what, this kid's probably going to get raped tonight around 6 o'clock. Under your policies, the state of Arizona policies, do we have to get a warrant or can we just detain the child from the home right there and then?
Again, you're going to go through, you're going to look at everything, you're going to get your collateral information. I can't go by a scenario, and I'm not going to be painted into a scenario off a statement and make what we would do. It's unfair to me, it's unfair to you, is take a statement and go whether or not we remove. Because it's more than just looking at a situation. You have interviews to conduct. Have you done an investigation, sir?
I have.
Okay.
So let's hold on.
Okay.
Let me just cut you
then
off
let me
right
ask
there.
you the question.
Sure.
Then would you make a removal off one statement?
Let's do this. Let's assume that the investigation's been done. You talk to the teachers. You talk to the doctor that confirmed this child's been raped. You haven't talked to the dad yet, but you've talked to everybody else you need to talk to. And yes, everybody's pointing to this child's going to get raped this evening at 6 p.m. What do we do?
I very well may. But again, I would want to do my own assessment.
But you definitely wouldn't go get a warrant because Arizona doesn't do that, right?
I have the ability to do an emergency removal in the state of Arizona.
Okay, let me try the question again.
I would not get a warrant because I don't need to in the state of Arizona.
Okay, that's my question.
Okay.
Have you ever, in any trainings that you've participated in or any conferences, anything like that, ever heard of a Ninth Circuit case called MABE, M-A-B-E, versus County of San Bernardino?
I can't remember.
How about Wallace versus Spencer?
I can't remember.
Don't sound familiar? Ram
Was that
versus...
no? Was that no? You shook your head. Was that a no?
I can't remember.
Ram versus Rubin?
I can't remember. I'm bad at names unless you told me what the case was about.
How about a dirty house? Is there any particular policy or anything in place, at least while you were working there, that deals with the situation where the house is just so dirty and there's, say, maybe a baby crawling around on the floor?
It would depend on whether or not it was a safety hazard.
Okay. And if the house being dirty is a safety hazard, then we'd remove the child without getting a warrant?
Again, I think I've answered this a couple of times.
Mm-hmm.
You can do an emergency removal if it's an immediate risk.
Okay.
If you don't think it's an immediate risk, they could have done a team decision-making meeting.
I'm sorry, a what?
If it's not an immediate risk, they could have done a team decision-making meeting and bring the family together to make a decision. But I think I've answered that a couple of times, maybe 3, 4. I don't know. It seems like I keep answering the same question.
So just to make sure that I'm clear, under your management, when you were there, if a social worker went out to a home, the house was just a slovenly mess, if in that investigator's assessment, that home living condition posed a risk to the child, it would be appropriate under policy to remove that child from the home.
Incomplete. Hypothetical.
Could have been. When I was there, we established in-home units. The purpose was to keep kids in the home. So there were, when I was there, 12 in-home units were created. Again, the major purpose was reunification. So
What the major purpose was for?
the major purpose was getting kids reunified and keeping kids in the home whenever possible. So I can't tell you. It just seems like you're thinking that DCS removes every child. That's not the case. Maybe that's what I'm hearing from you, and it's not accurate. I may be misunderstanding.
When you use the word reunification, what does that mean?
Reuniting families that have been or their
Separated.
children separated, yes.
Okay, so reunification, that connotes that the child must have at some point been detained from the home, right?
Mm-hmm.
Yes?
Yes,
And your major focus, at least while you were there, you got these 12 units, in-home units that were there to help families reunify, right?
yes, sir.
And we only reunify once we've been separated, right?
Yes, sir.
Okay, so I
Or-
want to focus on the part where we're separating, not the
Or
reunification.
families had in-home dependencies and were never separated. That was the purpose of those units.
Right, and
They were not separated?
They were never
That
separated.
was the purpose of those units?
Yes.
Is that what you said? You just got fading.
And an in-home dependency, that's sort of like where you would file a non-detained petition. That is where there's not, a huge emergency. We can go into court, we can file a petition, say, hey, look, Judge, we think we may have a problem here. Give us an order to do something, either provide services or place the child somewhere else or something like that, right?
And they all stayed with their parents.
Okay, so when you file a non-detained petition, those children will always remain with their parents? Yes?
When you filed an in-home dependency,
In-home dependency. Out there, we call them non-detained petition.
you're using language I'm not familiar with.
Yeah, I'm kind of figuring that out. Okay, so the in-home dependency, when you file a in-home dependency, that's the situation where the child, it's non-emergency, the child will remain in the home. Yes?
Yes.
Okay. Yeah, we're not really talking about that situation here today. What we're wondering about are the circumstances on the other side where your investigator thinks there may be some kind of emergent circumstance or emergency. So we're not going to do an in-home dependency, right?
Okay. So a child gets removed, and so I think we told you that we did not file a warrant.
You ever heard well, let me ask you this before we get to it. What about for suspected emotional abuse? Is it appropriate to detain a child from its home when we suspect there's some emotional abuse going on?
Incomplete hypothetical again.
Usually you can. It's difficult.
So when we're talking about that immediate risk of harm, that harm can include emotional harm.
It can.
When we're talking about physical harm as opposed to emotional harm, is there some gradation of harm that we have to look at? You understand what I mean by gradation?
Are you talking about severity?
Yeah, like severity, sure. Is there some level of severity that we have to look at when we're assessing harm?
Again, I think it would depend upon the kid's reaction. It would depend on, again, severity. It would depend on the parent's reaction.
So just so that I'm clear, when I'm out there as an investigator, I'm out there making this assessment, I'm not necessarily focused on the severity of the harm to the child. I'm focused more on how the child and the parents react.
What you're talking about is a child fearful.
Okay.
You're talking about you're watching the interaction between the parent and the child. You're looking at the demeanor. You're looking at what the siblings may say is happening.
Anything else? Okay. That doesn't really address my question. What I'm wondering is, I mean, we know that there's a spectrum of injuries that a child can sustain. They can stub a toe, or they can maybe break an arm. So on that continuum of severity of injury, from stubbing a toe or scraping a knee to breaking an arm, is there some level on that spectrum that the investigator is going to look at in considering whether or not we need to remove that child
They're
right now?
going to look at whether it is accidental or non-accidental.
Does the same hold true with respect to emotional harm? Accidental versus non-accidental?
They're going to look at the severity of, they're going to look at not the severity, they're going to look at how that child's reacting. They're going to look at how that child acts. I'm not sure how you have non-accidental and emotional harm.
I'm sorry, say that again.
I'm not sure when you emotionally abuse a child how that's non-accidental. Maybe you can describe that to me.
Well, I could, but fortunately for me, I'm not the one here under oath being questioned.
Okay,
Going,
I don't understand that, so.
That's fine. Let's go look at exhibit number 63 for a moment now. Bullet point number 3 on page number 2693 says, when there is present or impending danger and no other options are available to maintain the child in the home, remove and return them home safely as soon as possible. First, did I read that correctly?
Yes.
Okay. The second portion of that says remove and return them home safely as soon as possible. What are we talking about there? What does that mean?
Well, basically that means if they are removed and then there is a case plan usually made, services are put into place with the parents, and when the parents are compliant, and it depends also if court is involved. If court is involved, the judge decides when the kids are returned. If court is not involved and the case plan is followed, the kids are returned.
Okay, so if there's court involvement, just make sure I'm clear here. If there's court involvement, then the judge gets to decide when the children go home?
The majority of the time, absolutely.
What do you mean the majority of the time?
Well, I think in this case there was a different issue.
What was that?
Well, I think you're going to be asking me about that
I'm asking
later.
you right now. You said there was a different issue. Go ahead and explain it to me since you brought it up.
Okay. The department filed a motion on this case.
Okay. And
The kids were stayed to remain home.
who made that
Living.
decision?
That was a legal decision. That was a legal, with the staffing of the legal advice and the staffing of the field. It was discussed with the central office, and a decision was made to go forward with legal advice.
Staffing, you said that was discussed with staffing in the field?
It was discussed, it was discussed with the field on what was the concerns were of this case. And then it was also discussed with, and we had legal advice on the case, and it was discussed with my superiors, and then it was decided to go forward with filing a motion.
Okay, let's start with field. When you say it was discussed with field, who are we talking about? Who?
I honestly can't remember. I just remember that there was a staffing.
Okay, did you discuss the issues with somebody in the field?
I honestly can't remember. I just remember having a discussion with attorneys.
Okay. Then you said that there were discussions with your superiors. Yes?
I discussed it with my boss.
And that was who?
I cannot remember at the time, so I had several bosses in succession.
Generally, run me through the substance of that conversation, the one with your boss.
I would have just repeated what the concerns were and what the legal advice was.
What were the concerns?
There was concerns from Japan, and I don't remember the specifics.
Were there any concerns from Arizona?
There were,
Okay, what were they?
and I don't remember the specifics.
In order to figure out what they were, of course, somewhere they should be recorded or reported in some document, right?
Objective form, assumes facts.
Yeah, I don't have it. I haven't worked in the department for, so.
Okay, that wasn't my question. Can I have my question?
They should have been
please?
in the case manager's notes.
Okay, that's what we're looking for. It should have been reported in the case manager's notes. And according to policy, she needs to be very specific in those notes, doesn't she, about what her concerns are?
Objective form misstates prior testimony and also assumes facts.
If I'm wrong, tell me.
No, they should be noted.
They should be noted and they should be specific.
They should be in the petition.
And they should be in the case notes. Yes?
Yes, they should be in the notes.
Okay. So we should be able to go look at those notes and determine exactly what the concerns were with respect to the treatment of the children here in Arizona, right?
Or they would be in the petition.
Now, with respect to legal, all I'm looking for here is a name. Who was it that you spoke with?
You can go ahead and answer that, but what you guys discussed, we can't.
Pardon?
You can go ahead and answer who it was. And
Carolyn Moreski.
Can you spell that?
Moreski, I think. I can't remember.
And was the discussion with her before or after the decision was made to violate the trial court's order?
Objective form misstates testimony, argumentative, assumes facts. Go ahead and answer if you can.
It was before.
How long before?
I don't remember.
Give me an estimate. Minutes, hours, days?
I can't remember. I know it was after the judge made the order.
Was that by telephone, in person, or email?
Telephone.
How long was that conversation?
I honestly can't tell you.
You can give me an estimate. 10 minutes, an hour?
It was short,
Between 5 and 10 minutes?
I would guess. I don't know.
Well, you were on that phone call.
I was, and that was like 3 years ago.
Besides you and the attorney, was there anybody else on that phone call?
I can't remember. There was staff on it, but I think it was just myself and the attorney, but I don't know.
Then after that phone call, did you talk to anybody else?
I would have talked to my superior.
And that would have been,
I don't remember. I had several.
did you have more than one phone call with superiors after your phone call with Miss Morosky?
I would imagine I did, telling me what the decision was.
And then you would have had a conversation with Miss Wagner too, right?
I probably did, or one of her bosses.
Let me ask you, did you review any documents at all in preparation for your deposition here today?
Actually, no.
Did you have a conversation with Mr.
I did.
Bowen? When was that conversation?
Yesterday.
About how long was that conversation?
An hour, 30 minutes maybe. maybe shorter.
Why don't you turn to the next page in exhibit number 63. It's titled Present Danger. Is that what you were talking about when you were talking about imminent risk of harm?
Yes.
Okay. And here it actually defines it for us. It says, an immediate, significant, and clearly observable family condition occurring in the present, happening now, which will likely result in serious harm to a child. So let's break that down and talk a little bit about that. Significant and clearly observable family condition. What does that mean?
Well, basically, if we leave, and what my understanding of it is we leave and something would happen to that child. So basically, that child would be hurt and we left the home. So that would be hurt. So that kid, something would hurt that child. So if it would be severely hurt. So I guess.
And that's what you trained your subordinate investigators that were out seizing children from families, is just what you've told me there?
I'm sorry, what?
That's how you trained your
I told you I
workers?
did not train this document.
Well, you were the program manager, and under your supervision, that's how your subordinate investigators were trained, just the way you told me just there?
No, that was not.
Okay, well, let's hear it then.
I told you, I've been out of the field for quite some time, and I told you I'm not familiar with this document. I am familiar with the document. However, I have not done this. You can give me all the wonderful stares that you want to.
I'm just waiting for you to
but
finish.
I'm not proficient in this. So
Okay.
I don't know. So
You were the captain of the ship over there for 17 and a half years, yes?
I was.
Okay.
But
And over
did
the,
I do investigations? No. So I
So-
cannot give you the clear definition.
but I think we talked a little bit about this earlier, that you did have
Mm-hmm.
charge over the administration of training to your subordinates regarding,
Object to form, Ms. Stacy.
Can I
just wanna go
can I
ahead and-
clarify this because I'm
at
not
least
in
let
charge
me
of the
finish the
training.
question. At least
Okay,
let
you
me
can
finish
smile
the
all you want,
question.
sir, but actually training is defined by another section, and you can laugh. But I find there is a training section in DCS. So, do you have anything else you want to ask besides smile and laugh?
Can I get the first part of my question before the interruption reread, and that'll kind of get me back on track?
Okay, but I think we talked a little bit about this earlier, that you did have charge over the administration of training to your subordinates
Regarding the circumstances under, actually, I should just redo the whole question.
Well,
We did-
actually, can I
hold
clarify,
on.
because you
You've
did-
got to wait for the question. I'm sorry. You have to wait.
Right, just cool it. Wait till he finishes his question. You know,
I understand that you feel like you're under attack here, and I guess to a certain extent you are. But you have
just
to
ask a
wait.
question, don't
Hey,
do a
no,
speech.
no. I can deal with this any way I want. This is how
Just
I'm going to
ask
deal
your
with
question
it.
instead
If you
of trying
don't
to
like,
recite.
look,
It's
if
not that I
you
don't like it, I
don't
just wanna
like
get
the
this
way
thing
I'm,
done,
if you
and I don't
don't
need you
like
to
the
sit
way
here.
I'm
Sorry.
dealing with it, if you don't like the way I'm dealing with it, the solution's simple: suspend and get in front of the judge. Otherwise, we're going to run this as at trial, as the rules require.
Just
which,
ask
which
questions.
means
Don't make
you don't
speeches.
interrupt me. I don't interrupt you. He doesn't fight and object on his own and interrupt. He waits for the question and he answers it with a responsive answer. Those are the rules.
And those are the rules, follow the rules. Ask him a question, he'll answer the question, I'll make my objections.
That's
Just
fine.
do it, I don't need your speeches, he doesn't need your speeches. You can leave your speeches when we do closing arguments.
We're going to be here as long as it takes. And if you two want to make it take a week, that's what we're going to do.
Let's take a break.
Can
Can we
I?
take a break?
Yeah, we can have a break.
Okay, I have to be out of here at 1. And first of all, I came here because you
We're-
didn't actually subpoena me correctly. So,
Well, whether he did or didn't, that's not an issue. You're here, we're trying to answer his questions. You just ask the questions instead of playing the showboat game. I don't know why you can't just ask a question and have him answer it.
If
And
you
it's
don't like the
objectionable-
questions, then like I
It's
said,
not,
suspend
it's
it.
not a question when you're over here making a 3-minute speech.
We're
on
off
the
the
right?
record at 11:15. We are on the record at 11:28.
Let's go back to page 2703 of Exhibit 63. It's internal page number 13 of the training material. The first bullet point there on the slide titled Present Danger. It says, an immediate, significant, and clearly observable family condition occurring in the present, happening now, which will likely result in serious harm to a child requiring a same-day CPS protective response. First, did I read that correctly? It's the top page you're looking at right there. First bullet point. I can read it again if are you with me?
yes,
Okay, did I read that correctly?
you did.
Okay. You notice the now right in the middle of that paragraph. It's all italicized and all capital letters, right?
Yes.
Do you have any understanding why that is? Why it's all caps and italicized?
Because they wanted it to stand out.
To emphasize it, right?
Yes.
Meaning that now, that time component, that's important, right?
Yes.
Okay. And what they're telling us here is that the danger needs to be something that's happening right now, right?
Yes.
Okay. What was it that was happening right now that motivated you to instruct your subordinate to violate the juvenile court's order?
Objective form misstates testimony, assumes facts, makes up facts. Go ahead and answer if you can.
I can't tell you because I don't remember the specifics of the case.
Well, let's see if we can refresh your recollection, maybe help you out a little bit. Where is that? Show you what we'll mark as exhibit number 33 to your deposition, and you can take a moment and look at that and just sort of indicate when you're done.
Okay, again, this does not address the specifics of the case.
So I presume you're done reading it?
Yes.
Okay. If you look at the bottom of the first page after the exhibit number, that's page number 1355. Are you there with me? At page number
Sorry, the
one.
first page right here.
Yes, 1355. Look down at the bottom. There's an email there. It says from Karen Wagner, sent on June 13th, 2013 at 6:13 p.m. Do you see that?
Mm-hmm.
That's a yes?
Yes.
And it's sent to you, Gene M. Burns, right?
Mhm.
That's you?
Yes.
Okay. Who is Jacqueline Cercioni?
She would have been the supervisor at the time.
She would have been Miss Wagner's direct supervisor?
I'm not for sure. She would have been, no, she would have been probably the acting, or Lynn Hart was. I can't remember.
Okay. And then Jeanette Bell, who is that?
She would have been the deputy program manager.
So you're second in command?
Mm-hmm.
Yes?
Yes.
And then Sharon A., who is that? Or Sharon Canick, I'm sorry.
She would have been the assistant program manager.
So we have two assists, both of your seconds in command, two assistant program
She would have
managers?
been over. She would have been over the Avondale office.
Okay. And all of them were on the CC line on this email from Miss Wagner?
Yes.
And the subject was the Pellerin children, right?
Yes.
And then we can just sort of read this here together. It says, it's the second sentence in the email. says, I am just confirming that I am to serve a TCN to the family and not return the children. First, did I read that correctly?
Yes.
What is a TCN?
A temporary custody notice.
What is a temporary custody notice? What does that do?
It gives the department custody for 72 hours.
Okay. So she's confirming that she is to serve the temporary custody notice on the family and not return the kids to their parents, right?
Yes.
Okay. She goes on to say, we will be filing a special action request, and you are giving me permission to violate the court order not to return the children. First, did I read that correctly?
You did.
Okay. And she was addressing this to you. You were the one on the to line, right?
I am.
So where she says, you are giving me permission to violate the court order, she's talking to you, right?
Yes.
What court order was she referring to?
To return the children.
Do you know when that court order came down?
I do not remember.
Did you at any point in time actually pull up a copy and read that court order?
I did not.
And you were not present at the hearing,
I was not.
and you were not present when the trial judge, actually found Miss Wagner to not be credible. You weren't there for that either, were you?
I was not.
Okay. Did you come to learn at some point in time after this email that the trial judge, the finder of fact, had found Miss Wagner's story to not be credible?
Object before misstates testimony, misstates evidence, assumes evidence, or assumes information not in evidence.
I did not.
You never came to understand that Miss Wagner was found to not be credible.
Same objection, misstates testimony, assumes evidence.
Did not.
Now, you responded to Miss Wagner's email, right?
I did. Yeah.
And your response came at 6:15 p.m., about 2 minutes after you got this email from her. Yes?
Yes.
Okay, and we know that because we can see right above Miss Wagner's email, it says, from Burns Jean M., sent Thursday, June 13th, 2013 at 6:15 p.m., right?
Yes.
And that's, do you remember this email? You remember sending it?
I don't remember sending it. I remember, but
But you don't deny that
I'm
you
sure I
sent it.
did. I don't remember
Okay.
sending it.
Okay, but you don't deny you sent this email?
No.
Okay. And in your response, you tell her yes. The yes, is that in reference to her request for confirmation that you're giving her permission to violate the court order?
Yes.
Okay, so you gave her permission to violate the court order? It was you?
Object form.
If you read the second sentence, it clarifies what happened.
Okay. Did Deb Harper ever send an email to Karen Wagner telling her to violate the court order?
No. So I
Well,
told
hold on. The answer was no. You're the one that sent the email telling Miss Wagner, yes, serve the TCN, right? Mm-hmm. Yes?
Yes.
yes, after I cleared it with the Deb Harper, my boss,
Okay, and Deb Harper would have been
my superior,
at what location?
central office,
Okay,
in 1789.
let's get a little bit of an idea what the management structure looks like. You have a central office now, we know that, you just told me. And Deb Harper, what was her position there?
Deputy Assistant Director.
Who's above her, if you know?
Who was above her at the time? I think it would have been Veronica Bosick, maybe.
And what was her position?
Assistant Director.
And who was the director?
It would have been Clarence Carter.
Okay. Now, where you say, and we'll just go ahead and read the next sentence together of your email here. It says, this has been cleared with Deb Harper as well as the director's office. Did I read that right?
Yes.
Okay, so Deb Harper, we know she's an assistant director. What did you mean here in this email where you're telling Miss Wagner that the director's office has also approved her action to violate the court's order?
Objective form misstates facts.
Basically, what I did was I had called Deb Harper, explained what the situation was, what I had heard about the case, and my legal advice. I had talked to her. She had had her conversation, and then told me it was that I should inform the field to serve the TCN, and that it had been cleared through the office of the director.
Okay, so when you say she, you're talking about Deb Harper?
I am.
Okay, so it was Deb Harper that said, go ahead, violate the trial court's order, serve the temporary custody notice.
Mm-hmm.
Yes?
Yes.
And of course, that means that we're not going to return the children as
Yes.
ordered by the court.
Yes.
And so you didn't actually talk yourself with anybody besides Deb Harper at the director's office?
I did not.
Okay. In this conversation that you had with Deb Harper, did you yourself ever suggest to her that, hey, we've got a trial court order here, maybe we should consider some other approach?
No, I repeated the information, gave her the facts, and then gave her the legal advice.
Repeated the information. Repeated what information?
I repeated what was told to me, and gave her the legal advice that was given to me from Carolyn Moreski.
And what was told to you?
Again, what was told, not your legal advice, but the other information was told.
Yeah, gave the information. Basically, my major information came from Carolyn Moreski, which is from the attorney.
Well, wait a minute. This Carolyn Moreski, she didn't investigate any of the claims, did she? She didn't talk to witnesses or anything like that? She's just the lawyer, right?
But she had talked to her attorneys.
Wait a minute. What do you mean when you say she?
I went with my legal advice, plus what I knew about the case, plus what I knew about Japan at the time.
Okay, and what did you know about Japan
I
at the time?
cannot remember.
What's
It's been 3 years.
Okay. When you said that Carolyn Moreski talked to her lawyers, was this Carolyn Moreski, was she not involved in the
Carolyn
actual,
Moreski was a unit chief.
a unit chief? Was she actually a lawyer?
Yes.
But she wasn't the lawyer handling the dependency case. I'm sorry?
No,
Who is the lawyer handling the dependency case?
I cannot remember.
Who is Laura Gia?
Quinto. That
Quinto.
would have been Carolyn Moreski's superior.
What's her position?
I can't remember her exact title, but she would have been over the juvenile court attorney general's office at the state level.
Did you talk with her on the phone as well?
I did not.
Did you communicate with her in any way besides this email?
I did not.
Okay, so as
Not
far
that I remember.
Okay, so as far as you know, the directive to violate the order and continue to keep the children came from Carolyn Moreski?
Objective form assumes facts. And
I gave advice. I took it to central. I took it to my superior, and then I got direction back.
Okay, so who was it? Because, I mean, it could be that you have no fault here. Maybe you were just a conduit conveying information, you made no decisions at all, it was all somebody else. Or you participated in making the decision. It's one or the other, so that's what I'm looking for.
I am a conduit. I gave the I gave the information to my superior. I did not become involved in this case until there was a directive to return home.
Okay, so you gave the information to your superior, and it was your superior who made the decision to violate the order?
I can't tell you that because I don't know what my superior did with the information once she got it. So,
Now, when you spoke with your superior, and that would be Deb Harper, right? Mm-hmm. Yes?
Yes.
Yes.
Yes. You got to remember, she can't.
Okay, sorry.
Yeah, she's trying to write it down. It's got to be yes or no and that sort of thing. And Deb Harper is, when you say, I spoke with my superior, we're talking about Deb Harper.
Yes.
Okay. When you spoke with Deb Harper, describe how that conversation went. I know you're not going to be able to remember the substance of it, but was it a give and a take? Did you guys bounce ideas off each other? I mean, how did that go?
I just remember that she had cleared everything. I thought she said with the director's office, and that we should remove. She had talked to, and she had also gotten legal advice, and that's why I included Laura.
Okay, so just so I'm clear on the sequence here, you got this email from Karen Wagner just to confirm that, yeah, she's got your permission to go out and violate the court order. Yes?
Yes.
By the time you got this, you had already spoken with Deb Harper and Miss Moreski.
Yes.
Okay. And you'd also spoken verbally with Miss Wagner.
I can't tell you if I did or not, because I don't remember.
Okay. And it was in that conversation with Deb Harper where she told you, go ahead, violate the order, remove the children.
Said remove the children.
Okay, she didn't know about the court order?
She knew about the court order.
Okay. So she said, Deb Harper directed you to go ahead and remove the children.
Said we were going forward as a department to remove the children.
Okay, and when we talk about removing when we talk about remove the children, that's basically we're not going to give the children back, even though the court has ordered us to do so.
We were going to take further legal action.
Okay. And you don't know what Deb Harper did on her end.
It'd only be speculation on my part.
Okay. All you know is she told you I cleared this through the director or something like that. Yes?
Yeah.
The director's office.
Here in this case notes, what is this? What is this document?
I'm sorry, what?
This exhibit number, what was this?
33.
33, the second page, 1355, up in the top, big bold letters, underlined, all caps, says case notes. What is this?
This is a case note that looks like somebody cut and pasted a document, in, an email document in.
Okay. And here, where it says author Karen Wagner, does that mean that she's the one that authored this case note?
I believe so.
And I think you just mentioned it looks like she took that email string and sort of cut and pasted it into the body of the case note. Mm-hmm. Yes?
Yes.
Okay. Am I correct that somewhere floating around in there, out there in the ether, there's an actual email string?
Should be, yes.
Okay. Do you know how we go about getting that actual email string?
I do not. They have an IT department.
When you were the program manager there, did you guys have a general email document retention policy?
If there was a suit or something, something came out saying you're supposed to send your emails to, I can't remember a particular person, but that was it.
Okay. But generally speaking, let's ask this way. Did you have any responsibility at all for discipline of your subordinates?
Yes.
And from time to time, if disciplinary issues came up, did you have the ability to go back in time and audit their emails?
Yes, but that was usually done by IT or somebody that goes back and audits emails. That was not done at the field level.
Do you have any understanding as to how far back they could go?
I do not.
Okay. But you know that they did have some archival capacity and did have some ability to go back and pull up people's old emails?
Yes, but I don't know how far.
Okay. Now here in your email to her, you gave a cell phone number. Was that common practice to give out your cell phone to your workers?
Yes, everybody had my cell phone number.
Okay.
It was on the directory.
Okay, so this wasn't something special where you're telling her, hey, look, I know this might be an issue, call me on my cell phone.
No, no, I always gave my cell phone number out.
Here in her case note above your email, it says, and it's the third line down, second sentence, about the middle of the page, says the department decided in the best interest of the children that CPS will not return the children to parents and will serve a new TCN. And again, that's a temporary custody notice, right?
Yes.
Just for clarifying, did you say it in an email? Because this isn't part of the email.
No, I did not say
Okay.
that. Am I correct? TCN is temporary custody notice?
Yes.
Okay. And somehow, I presume during this conversation with Miss Wagner that you've talked to me about, somehow in the continuum of those events, it was decided that it was in the best interest of the children to keep them away from their parents?
Yes.
Okay. In what way was it in their best interest?
Foundation.
Like I said, there were concerns about the Japan, and I can't remember what those concerns were.
Now, there was a hearing, right? Before this email exchange took place, there was a hearing in front of a judge?
Mm-hmm.
Yes?
Yes,
And Ms. Wagner testified, didn't she, at that hearing?
I believe so, yes. I wasn't there.
Ms. Pellerin, she testified at that hearing, right?
I don't know, I wasn't there.
Well, you talked to Ms. Wagner about that, right?
I told you I don't remember talking to Miss Wagner.
Well, you talked to all these other people when you guys came up with the idea that we could just serve a new TCN.
Juxtaform Ms. State's testimony, prior
I
testimony.
told you I don't remember talking to them. I don't remember the conversation if I did.
So you don't even remember generally having an understanding on June 13th, 2013. You don't remember having a general understanding that an actual evidentiary hearing took place.
I remember there was a hearing.
Okay.
I was over a lot of cases. I remember the concerns about Japan. I remember that the judge would not hear the concerns about Japan, and the department felt they were relevant.
You don't remember that Ms. Wagner actually took the stand, swore an oath, and testified?
I wasn't there, so how can I remember that?
Well, nobody ever told you that.
That's part of protocol. So how can I say something when I wasn't there?
I understand, but I mean, I'm not at my daughter's volleyball game, but she told me she won, so I know she won.
Okay.
So I'm asking you, did
Again,
somebody
I
tell
told
you?
you I don't remember. I don't know how many times I can say that.
Well, I just want to get to the bottom of it and see what you do remember, because oftentimes, although we may not remember specifics, we remember general things, and as we think about it, more stuff pops up and we remember more. That's all I'm trying to do here.
I just remember the Japan issue.
Okay.
That's what sticks out most to me about this case.
And what do you remember about the Japan issue?
I don't specifically remember the specifics. This case, because it was unusual, because of the Japan issue, and that's why it sticks out to me.
Okay. And was the issue that there had been allegations made against these parents in Japan? Was that the issue?
There were allegations, and I was trying to remember. I can't remember. I thought they were pretty severe, if I remember correctly, but I don't remember what the allegations are now.
Okay. And you also remember that, you know, your sort of counterpart in Japan, they have their own version of
I do.
Child Protective Services, right?
I do.
They may call it something else, but it's the same sort of function. You remember that?
Yes, for the base.
Okay. And you also, I presume, remember, and you'll tell me if I'm wrong, that the allegations there had been investigated, right?
Vaguely.
Okay. And that the investigator who actually did the interviews, he went out and he talked to people, he found that there was insufficient evidence to meet the criteria for any kind of abuse. You remember that?
I do
Ms.
not.
State's facts.
Did you ever read his report before coming up with this idea that we should disobey the trial court's order?
I remember reading something from Japan, Like I said, I do not remember the specifics.
And then the military, they ultimately found that there was insufficient criteria to meet, or insufficient evidence to meet the criteria for abuse. You remember that?
I do not.
Okay. And you never read that letter that came from the military?
I don't remember.
Okay. Is it fair to say that on June 13th, 2013, you had incomplete information?
I don't know. I don't remember. I don't remember.
Well, let me ask you, if you have incomplete information, is it appropriate, in spite of that lack of complete information, to violate trial court orders according to policy?
Well, you're asking me, can you restate your question?
Can I have it reread, please?
Well, let me ask you, if you have incomplete information, is it appropriate, in spite of that lack of complete information, to violate trial court orders according to policy?
Okay. Not regarding this case, the answer would be no, I should not violate.
But in this case, even though you had incomplete information...
I don't know if I had incomplete information because I don't remember what I had.
The information that you did have at the time this decision was made, would that be documented somewhere? Did you take
It would
notes?
be somewhere, and it should be somewhere in the case notes or in the file.
So when you say it should be in the case notes or the file, I take it to mean that those are two different things?
They are.
Okay. And if it's in the case notes, would it be there because you yourself documented the evidence that you had in assisting you to participate in making this decision?
No, the
Is that the
case.
form of some facts?
No, the case notes are something you could read online.
Okay, so it's not something that you would have put any information into.
No, there's something that you could just go online and read
Okay.
in the child system.
And the case file, when you say the file, what are we talking about there?
It's an actual hard file they have in the office.
What sort of information would we expect to find in that file that you would have relied on at this point in time in June 2013?
It would be reports, if anything, letters came from Japan, it would be something like that.
Okay, so for example, the witness statements from Japan might be there.
If they sent in a hard copy, it would be there.
And as part of your involvement in this process of deciding to violate the trial court's order, you didn't actually call and talk to any witnesses.
I can't remember.
Okay. If you had called and spoken with any witnesses, where would that be documented?
I don't know if I documented it.
Isn't it, according to policy, isn't it required that any contacts with collaterals or other witnesses be documented in the computer somewhere?
I didn't, it wasn't part of the investigation, so it's just something I was reviewing.
Okay, when you say it wasn't part of the investigation, is that because as a program manager,
I was having discussion with the AG.
okay, you don't normally go out and talk to witnesses as a program manager, right?
Is that an answer?
No.
Let's
I did
take a
not.
quick break.
We are off the record at 12 p.m.